welcome to our November 2024 data protection update. For those of you who don't know me, my name is Martin Sloan. I'm one of the partners in the commercial services team at Brody's and specialising in data protection law. And I'm joined today, as ever, by Grant Campbell, who is one of the other partners in the team, and Rachel Lawson, who is an associate. So for those of you who've joined us before in these webinars, it's the usual format. We'll be looking at some of the key developments over the last 6 months or so since we last spoke, which I think would have been May or June time earlier this year, and things that you may have seen that we're going to deeper dive on, or things that you may have missed that we will pick up on that may be relevant to what you've got on your desk. So if we just turn to the agenda, what we're going to cover today, well, first off, we're going to talk about reform. So we've got the new Data Use and Access Bill, so I'll be talking a bit about that. I'll then hand over to Grant, who's going to talk about AI and some of the developments we're seeing around that in relation to data protection and privacy. And he's also going to talk a bit about the Dixon Stores ICO fine appeal and some interesting stuff that may come out of that in relation to what we think of when we're thinking about personal data and how that definition may be impacted by that decision. Rachel's then going to talk about controllers and processors and some interesting developments there. I will then talk a bit about some new cyber laws that are coming down the track, and then back to Rachel for talking a bit about cookies and what's going on with that since we last spoke, and also on subject access requests. Okay, so let's go into the Data Use and Access Bill. If we just flip on to the next slide. So the first question I had with this was what I was going to call it. So I ran a poll on LinkedIn a couple of weeks ago just to see if we could settle on an agreed way to refer to it, DUAB, or is it DUAB or DUAB? And if we put the results up on screen, we had a fairly comprehensive vote in favour of DUAB, so that's what I'm going to stick to for the next wee while. And my wife, who's a government lawyer, pointed out that actually we shouldn't include the B in the acronym because it will become the DUA Act in due course. But for the time being, I'm going to stick to DUAB since that's what we I think we've decided we want to call it. And as many of you know, we've spoken on these sessions before. If we can move on to the next slide. About the previous Data Protection and Digital Information Bill, which was brought by the previous government. That didn't make the wash up, and you may remember our last session was I think pretty much the last day of Parliament, and that bill fell. But actually, what's come back with the new government is remarkably similar to what we had before. And just to make that point, you'll see on screen there a comparison of the introductory text for the new bill versus the DPI bill, and you'll see with the green text, actually a lot of it is just stuff that is moved around. The content of this bill is remarkably similar, and having run a comparison, I would say about 80 to 85% of it is the same as what we had before, if not more than that. If we move on to the next slide, we can see here, so this is the structure of the previous DPDIB bill, which had a number of different parts, a number of schedules. And then if we flip forward, you can see here the structure of the new bill actually is very similar. It's just stuff that's been shuffled around, but the key sections that are in here, the key parts of the bill and the schedules are all very much the same. It's just that the order has changed. So for those of you that spend a bit of time getting familiar with the old bill, the good news is actually you'll have a good starting point for the new bill because a lot of it is largely the same. There are a few things that didn't make the new bill, so if we flip forward to the next slide, I would just, on to the next slide, take you through those. So there's a couple of things that haven't been kept in the new bill. So first off, you may remember that there were proposals to amend the definition of personal data, particularly around identifiability and some of the tests around that. Those changes are not in the new bill, but as Grant will talk about, we do have the Dixon Stores appeal itself actually impact on how we define personal data, particularly when it's in the hands of third parties. The other big change is that a lot of the proposals to make the accountability obligations less prescriptive have gone as well. So you may remember that There was a proposal to limit when you needed to do a data protection impact assessment, or to keep Article 30 records. And the role of a DPO was going to be dropped in favour of a senior responsible individual. So all of that is gone. We are keeping the sort of compliance framework that we're familiar with under GDPR. If you're a charity or a third sector organisation, then you will no doubt be disappointed to know that the proposal to add in soft opt-in under PECR for the benefit of charities and political parties has not been included. So that's not been brought forward. That one's a bit of a surprise. I expected that still to be there because there's a lot of support for ensuring that charities can benefit from soft opt-in in the same way that commercial organisations can. And I saw that earlier this week, the Chartered Institute of Fundraising wrote a letter to MPs and the Lords requesting that that is reconsidered, and that goes back in. So I think that one may be one where we may see an amendment and that may come back in. But for the time being, if you're in that sector, there is no proposal to get the benefit of soft opt-in. In terms of international application, you'll be familiar with the requirements under data protection law to have a local representative if you're caught by the extraterritorial provisions. The previous bill had proposed removing that requirement to have a UK representative, but that has been dropped from the new bill. So that requirement will still apply to anyone outside of the UK who is caught by the extraterritorial provisions under data protection law. And then the final major thing that's not part of this is that the previous bill had a requirement for the ICO to have regard to the government's strategic priorities and powers of the Secretary of State to input into codes of practice. That has been removed. That was one of the areas where the previous bill was criticised as perhaps interfering with the independence of the ICO. And so that is now gone, and those concerns will hopefully have gone away. So what does the bill do? If we go on to the next slide, I will just take you through the key changes. So first off, for those of you that ever are processing and looking to rely upon the public task condition, the bill clarifies that this can only apply. It has to be a task that's carried out that must be that of the controller. So you can't borrow the public task of another organisation in order to rely on that as your legal basis of processing. But there is a new recognised legitimate interest in relation to disclosure of information to a person carrying out a public interest task. So while the public task condition has been narrowed, there is a recognition that if, say, a public body is asking for information to be shared with it, that you may be able to rely upon legitimate interests to share that information with that body, but subject to your legitimate interest assessment. And on that, we have now a number of recognised legitimate interests. So that again, this was proposed in the previous bill, but the point here is that say if you have to do the full legitimate interest assessment you'd have had to have done previously, but you do still need to carry out a test around necessity as to whether it's necessary to do that processing. So you don't need to do the balancing test, but you still got to consider whether what you're doing is necessary for that purpose. So you'll see on screen there, we've got recognised legitimate interest for direct marketing, intragroup transfers of personal data for administrative purposes, security, there's the public task condition that I pointed out there, and then some in relation to public security and national security. Just on the disclosure to a person carrying out a public interest task, one of the things that the ICO has pointed out here is that there's potentially an accountability gap, because if you are disclosing that information to someone else, you're doing it on the basis of what they have told you, but the public authority doesn't become the controller of that processing until they receive the information. So they just flag there's potentially a bit of gap there in terms of ensuring that that original transfer is lawful and necessary. So we may see some development in that. In relation to research, the provisions that were in the previous bill are carried forward. So this deals with things like further processing, so the purpose limitation test, providing a bit more flexibility than that, which I think would be welcome to organisations that carry out research, but also saying that research includes commercial research. So previously there was an understanding that research had to be for non-commercial purposes, but the bill will make clear that that can include commercial research too. And also tied to that, there's also a broadening of the interpretation of consent for research. So one of the big problems with research is that when you collect the data, you may not know exactly what you're going to do with it, and therefore your consent, if you're relying on consent, may not be terribly clear in terms of what you're going to do. But the bill provides a bit more leeway in that in terms of um, how you apply consent and how transparent you need to be on what research you may carry out. In terms of privacy notices and the right to be informed, we have some changes coming here as well. Again, this is carry forward, and this just really builds on when it would be a disproportionate burden to have to communicate your privacy notice to people where you're not getting the data directly from them. This very much ties into the Experian case that we talked about last time around, and it's the bill references things like considering the number of data subjects, the age of the held the data is, and appropriate safeguards that are being applied. But you remember with Experian, they had a large amount of data, but they hadn't communicated to individuals about what they held because they said there was a disproportionate burden in doing so. And this bill is picking up on that point and providing some clarity around when organisations will be able to rely on that exemption not to provide the privacy notice. Okay, on to the next slide. So some other changes. So in terms of data subject rights, a lot of what's going in here is actually really just codifying what the ICO already says in its guidance. So stopping the clock when you're checking someone's identity. If you are concerned about that, then the time period responding is paused. And also codifying the expectation that controllers only need to carry out reasonable and proportionate searches. So that will now be reflected in law, just rather than in the ICO's guidance. There's also some wording on it as well, which brings back something from the 98 Act around the ability of a court to have the power to require information for review when they're dealing with a court action for disclosing information under a DSAR if they want to actually look at the underlying data. On international transfers, again, what's happening here is really, I suppose, codifying what the practice that we've had over the last couple of years. And there's now the key test is about looking at whether the standard of protection will be materially lower than the standard protection provided in the UK. So when the government's carrying out an adequacy assessment, this is the standard that will apply. And in relation to transfer risk assessments, again, we're seeing the ICO's guidance codified within legislation. On automated decision making, this is one which I was slightly surprised at. And this is a new thing that's come in, particularly given all the concerns around AI and how accurate AI is. That the proposal is that the rules within data protection law on automated decision making, which previously applied where you had a legal or similarly significant effect, will now only apply where that data is carried out using special category data. So that significantly narrows the extent to which data protection law will regulate automated decision making. And I say, I think just in the current climate, that for me was certainly a bit of a surprise, given that there are many decisions that are made on an automated basis that may not have any special category data, but you may have algorithms, for example, for deciding whether to offer someone a loan or a financial product or something like that, where the automated decision-making rules would no longer apply because that's just using financial data or other stuff which would be special category data. And then finally, on data subject complaints, there are some amendments to the process around that. So there's an expectation that you'll first complain to the controller before you go into the ICO, but controllers also have to have a complaints process in place, and there's a suggestion that organisations might introduce a complaints form. There's a requirement in terms of how quickly you acknowledge that complaint. But there may also be some secondary legislation coming, which also puts obligations on controllers to report on the number of complaints received. And I know within some sectors that could be quite challenging to do in terms of how you actually track that. What is a complaint? Will there be any sort of materiality around the level of complaints reported, or do you have to report everything? So await further comment on that from the government in terms of how they might implement that. Then on to the last slide in this section. So just in terms of other changes on PECR and electronic marketing, The maximum fines will now be matched with UK GDPR, so that hadn't happened until now, but the intention is that the same fine levels will apply under PECR as they do under UK GDPR. And then we've also got carried forward proposals around the use of cookies, including saying that first-party cookies used for analytics and some other ones will not require consent. So that I think is kind of really taking some of the discussion we've seen around the use of cookies and things which are lower risk and saying, well, actually, these are necessary and therefore you don't need prior consent to use those. So that will be welcomed by many. The Information Commissioner will get a new structure, so it will no longer be a corporation sole, an individual. It will now become a statutory body. It will be the Information Commission. So I'm not sure if we're going to call it the IC or the IC. It was a discussion a couple of weeks ago where that provoked a bit of humour around an IC response to how you do things, but we'll see how that pans out. And the current commissioner will transition into the role of the chair of the Information Commission. So some structural changes there, which I think the ISO has certainly welcomed and have been talked about for a while, and so should be welcomed. And then just two other things just to flag on the bill. So a lot of this is about data protection law and reform of data protection law, but it's also going to introduce a new framework for digital identification verification services. Which is, I think, overdue, given that a lot of that's based on EU law and the changes that have been going on elsewhere on that. And then the final thing just to mention is around smart data. So this is around codifying and providing new regulations for things like open banking and ways in which consumers and businesses data can be shared, builds on the concept of data portability. This section is very much around enabling legislation to allow the Secretary of State to make regulations, but there is quite a lot of that in there if you're in the sector where you envisage there being sharing of data between organisations or that consumers may want to make. So worth looking at that as well. That's all I was going to say on the bill. Hand over to Grant, who's going to talk about AI.
Thank you, Martin. For those of you who may have seen me right at the start in the dark, I'm broadcasting from a slightly different place than my usual spot. So I've been having a bit of lighting difficulties, but hopefully you can see me and it won't spoil the presentation. So latest on AI. Next slide, please. I want to start with the UK. So you'll be aware that the ICO has been embarked on a series of calls for evidence, basically testing the market, going out and asking people for their views on key issues to try and understand how AI is working, and to then bring that back to bring proposals for regulation and guidance in terms of the data protection and privacy aspects of AI. So I'll recap just on each of the calls for evidence. There are 5 in total. So the first call was on looking at the lawful basis for web scraping, and that was in March 24. And I suppose the headline from that was legitimate interest can be a valid lawful basis for training generative AI on web scrape data, but you need to go through a proper legitimate interest assessment test in order to be able to use it. The second call for evidence followed hard on the heels of the first one. So this is about purpose limitation in the Gen AI lifecycle. And not surprisingly, ICO is keen that developers set the purposes for which they're processing data throughout each stage of the development, and they explain what they're doing and why they need it in order to meet a stated purpose. So it's a purpose limitation and making sure that they're only collecting the right amount of data for what they're collecting. And we'll see, I'll come on to talk a little bit later about how that has impacted the ICO's review of one particular sector. The third call of evidence followed again in May, and this time was on accuracy, and that picks up on the point that Martin's just been making, I think, in relation to automated decision making. So developers need to actually have a really good understanding of the accuracy of the training data they're using to develop their models, and they need to communicate this to users. So again, very much a focus on accuracy and making sure that the data that goes into the AI hopper is accurate. Can we take next slide? The fourth call for evidence in the summer, June 24, was on individual rights. and it was all about developers and users of AI having effective processes for individuals to exercise their rights in relation to their data, uh, and actually putting the onus on developers and users to actually be able to evidence how data subjects can get access to their personal data. And if you're going to rely on exemptions, you need to be able to justify them. So very much tying into the accountability piece under data protection law. The fifth call for evidence, which was in September, was on the roles of the various participants in an AI chain. And what the ICO said there is that these roles must actually reflect the actual levels of control and influence for which each data processing activity is taking place. And I think the ICO has found, and well, again, I'll come on to this, that there's quite a lot of woolly thinking about who's actually a controller and who is actually a processor, with a number of AI developers claiming simply to be processors, when the ICO, certainly from the comments that have been made, thinks that they're actually a controller. Or, and that was something that came out very strongly in the ICO's call for evidence, that actually participants in the AI supply chain should be seriously considering whether they are in fact joint controllers, and not to shy away from that as an outcome. We've heard through various conferences and chats from people within the ICO that, having done the 5 calls for evidence, the consultation is now closed, so that exercise is now closed. The ICO is currently wading through what they say hundreds of responses, and with the aim of publishing a consultation response later this year. So that's literally not much time, moving a month left in 2024. And then the aim is to update the wider AI guidance in due course. So that's the timeline. The consultation around all of these things is closed. ICO is now reflecting on the responses it's received. It will publish a draft consultation, and then will aim to update its guidance once it's had a response to its consultation. So very much expect this will be something that we'll be talking about when we do our next session, probably around May time. So if I can take the next slide, and this is a very recent thing. So the ICO conducted consensual audits of a number of developers and providers of AI-powered recruitment tools. So AI can automate and simplify recruitment processes through various activities for application screening, shortlisting, profiling, aptitude tests using algorithms, and automated background checking. So there's clear drive for a lot of organizations to use AI-powered tools to do that. What the ICO, having audited, and I should be clear, the report does not identify the organizations that were actually audited, but they clearly engaged constructively with the ICO. But the ICO broke down a number of concerns that it had. Basically, I've grouped them as 4. So first one was in relation to discrimination and bias. So some of the providers of these solutions were not regularly testing and couldn't demonstrate that they were accurately they were testing the accuracy of what the AI was actually doing. And examples included filtering out candidates with certain protected characteristics. On accuracy, examples of things that weren't quite right. So some AI tools assumed inaccurate characteristics about a candidate, their gender or their ethnicity, based on the candidate's name or other candidate information, and got it wrong. There is also a concern around excessive data collection. So some tools were collecting far more data than was necessary, including web scrape data from social media sites without the candidate even knowing that that was happening. And I think there were also concerns about how long that data was being kept and what it was then subsequently being used for. Was it then being used to go back to further bulk up the underlying data that it was continuing to learn from? And then finally, picking up that point on the 5th call for evidence, in terms of transparency and roles, AI providers often labelled themselves simply as processors, when in the ICO's view, they were clearly controllers or joint controllers. And as a result of that, contracts that were in place with these AI providers tended to be often vague and unclear. Next slide, please. So the ICO has made a number of recommendations for organizations who are intending to engage providers of AI tools for use in recruitment. None of these, I think, should be surprising. I'll quickly run through them. None of them will be surprising to data protection lawyers, but I think what it does is this report for me kind of signposts, I think, where the calls for evidence and the ICO's likely consultation and ultimately guidance are going to go. So the recommendations included ensuring there's a lawful basis for processing and making sure that that lawful basis is clearly set out in contracts and in privacy notices. ICO is very keen that organizations looking at AI tools in this area conducted DPIA early on in the process and continued to monitor it as the tool gets refined and trained and developed. Those that are looking to use AI tools need to make sure that the data is processed fairly. Again, this comes back to accuracy, bias, and also the use of special category data. They should also take steps to ensure that the provider has measures in place to mitigate bias and ensure the tool is being used transparently. Inform candidates that AI tools may be used to process their data, for example, in a privacy notice. So you have to be explicit about that. Collect only the minimum possible data required, and there are only limited numbers of data sets that are required for a recruitment exercise. Clearly define the scope and nature of the relationship with the AI provider and what each role is, and set out the responsibilities accordingly. So avoid these vague and unclear contracts that were picked up in the ICO's audit. And then I guess part of that, which following on, is making sure that there are explicit instructions, particularly if you're dealing with processors, that there are explicit processing instructions with full details of what data is being processed, how and why, and what the output will be, how it will be stored, how long it will be retained for, and who it will be shared with. So none of these are surprising, but I think they are pointing in the direction of where the ICO is likely to go with the guidance that's going to be issued next year. So that's an overview of what's happening in the UK at the moment. I'll very briefly turn to just quickly look at the EU on the next slide. So you will remember from previous talks, the EU has taken a different approach to the UK. So we now have the EU AI Act, which came into force, or at least started to come into force in August this year, with quite a long and detailed set of transitional gates to go through to about 2027. What we're seeing now is the start of the EU starting to flesh out some of the details that will support the actual act itself. So we saw this month the AI Office, the European Commission, has published the first draft of a code of practice for general purpose AI models. And this is envisaged in the EU AI Act. There are provisions, I think, in regulations 56 and 53 for codes of practice to be issued. The draft that was issued was very light on detail. It was essentially an invitation for interested stakeholders to set out their views. I think it's the start of quite a long consultation process and drafting process, but it has been kicked off. Secondly, the European Commission, again, the AI Office, has been consulting on future guidelines as to the definitions of what an AI system is and what practices pose unacceptable risks. So again, this is stuff that's going to flesh out detail under the AI Act, and the consultation for that closes, I think, in early December. So if you still have views on that, and you can make them known, you still have the opportunity to do so. And finally, the other thing I wanted just to mention was the AI Pact. So back in September, European Commission was publishing details of a voluntary set of commitments from organisations who had agreed to sign up to them. Some of them quite significant, certainly over 100 organisations who had agreed on a voluntary basis to try their best to comply with the principles in the EU AI Act, even though they're not yet in force. So you can see that the EU are kind of trying now to work through some of the detail that's going to then flesh out the compliance regime that organisations are going to be required to comply with in the latter part of 2025. And again, we'll keep monitoring that and talking about it in our next sessions. So that's what I wanted to say about AI. I wanted now to talk about the Dixons or the Curry's case, depending on how you remember them. So if we move on, so this is a case that's put personal data definition in the spotlight. I'll quickly run through the chronology so we can go on to the next slide. So the facts behind this are briefly, in 2017, there was a cyber attack on DSG's point of sale system affecting about 14 million people and the records. In 2020, the ICO issued a monetary penalty notice for £500,000. And bear in mind that given the date of the actual attack, this is all regulated under the 1998 Act, so £500,000 was the maximum in those days. In 2022, the DSG appealed to the first tier tribunal, who reduced the fine to £250,000, but the DSG was not happy still with the outcome of that decision, and so they appealed to the upper tribunal, and they gave their decision in September 2024. And there are quite a lot of complex issues, a lot of different appeals and arguments, but I want to focus on one of them. So the upper tribunal granted DSG's appeal and remitted the case back to the first tier tribunal to be redecided. The ICO has indicated that it intends to appeal one aspect of the upper tribunal's decision, and this will go to the Court of Appeal, so out of the tribunal system and actually into the main court system. And the issues raised in summary are about the fundamental concept of when data is or is not personal data in the hands of third parties, and how that fits into the 7th Data Protection Principle about taking appropriate technical and organizational measures to prevent unlawful or unauthorized or unlawful processing of personal data by third parties. So the background to this, just a little bit of context, in relation to this particular issue, there were over 5 million payment cards affected. Most of them were protected by EMV protection, which mainly chip and pin, which wasn't compromised. However, about 5 million cards had their 16-digit card numbers and their expiry dates compromised. No cardholder names, just the card numbers and the expiry dates. So the ICO and the first tier tribunal concluded that there had been a breach of the security principle in relation to that data, because the data was personal data in the hands of DSG. DSG either knew who these people were, whose cards they were, or could work it out from other information that they have in their possession. And that's kind of been classed as the first two limbs of the test for whether personal data is, or whether people are identifiable and therefore data could be personal data. So the ICO and the first tier tribunal said, look, the test here is this personal data in the hands of the controller? If it is personal data in the hands of the controller and it is compromised because the controller did not take appropriate technical and organizational measures to protect it, then that is a breach of the 7th principle. Could you turn to the next slide, please? DSG contended that that was wrong and that the first tier tribunal had erred in law, because the requirement to take appropriate measures was designed to protect unauthorized and unlawful processing of personal data by third parties. But in this case, the data in the hands of the cyber attackers wasn't personal data, because they had no means from the payment card number and the expiry date to actually identify the individuals. So it was in effect vanilla data. And what had happened was that actually the data that had been released to attackers wasn't personal data in their hands. They couldn't process it in an unauthorized or unlawful basis because it wasn't personal data. Now that argument emerges from looking at the statutory definition of personal data when read in conjunction with recital 26 of the directive. And that recital 26 talks about anonymity of data and actually how you consider whether data is anonymous in the hands of third parties. And you have a test that's been called the reasonably motivated intruder. So, if somebody is reasonably determined, could they unlock the key to that data from other information that they have or could get? And this line of attack came out of a decision that was originally made by the House of Lords in 2008, the Common Services Agency, the Scottish Information Commissioner. It was a Scottish case which we were actually involved with. And that was about the controlled release of data when you were considering FOI obligations and whether or not you could disclose personal data in response to an FOI request. And there the court had been reasonably clear that if the data was effectively anonymized, then actually it wasn't personal data and therefore it could be released. So the argument here is extending it to say, okay, this is not a controlled release of data, but the same principle should apply. The data that's in the hands of the third party is not personal data, and therefore the seventh data principle has not been breached. So the upper tier tribunal concluded, firstly, that the data was personal data in DSG's hands. So that I think is obvious. But what it said is that doesn't necessarily mean it's personal data in someone else's hands. So the data security principle was concerned about the risk of unauthorized or unlawful processing of personal data by the third parties and the harm that might follow. And that had to be judged from the perspective of the data that the third parties could access as a result of these alleged failings. Was the exposed data personal data in the hands of the attackers, not just the controller? And the upper tier tribunal concluded that the data that had been exposed was not personal data in the hands of the attackers. And as a result of that, the seventh principle had not been breached. So that's quite a controversial decision. I think the Court of Appeal will hear this, and it'll be very interesting to understand where that goes. It may ultimately end up in the Supreme Court. So the ICO is unhappy with that particular decision, and the appeal is pending. So we will report on that the next session. Can I hand now over, please, to Rachel?
Thanks, Grant. So moving on to the next slide, just an update here. So while we'll all remember that only controllers were directly subject to the obligations within the Data Protection Act 1998, we'll all be aware of the change with the advent of GDPR that brought processors directly within the remit of the GDPR obligations, with supervisory authorities given powers to take enforcement action directly against processors. However, in the UK, at least since 2018, there's been very little direct focus from the ICO on processors who have generally remained unscathed. But in August, the ICO published an intention to fine Advanced Computer Software Group Limited in relation to various failures to protect personal data as a processor. So what happened here? Well, the failures the ICO found are not anything surprising. Advanced was found not to have employed multi-factor authentication, leading to hackers taking control of a number of its systems through a compromised customer account. This led to the threat actors gaining unauthorised access to the personal data of just under 83,000 data subjects. As an NHS supplier, the information ranged from phone numbers and medical records to, in some cases, information on how to access people's homes for those receiving personal care. The ICO said in its intention to find that as a major NHS services provider entrusted with looking after a large amount of individuals' data, it should have had better systems in place. As well as a lack of MFA, the ICO found a lack of checking for vulnerabilities, and there was no regular security patching. So why is this significant? Well, this action demonstrates that while the ICO may have been slow so far to focus on processors, they are certainly not incapable of being subject to formal action, particularly where the ICO finds considerable failures to follow the standards which apply to processors within the GDPR to protect personal data. Organisations acting as processors are subject to explicit security obligations, and this serves as a timely reminder of the potential for direct regulatory enforcement if they fail to prioritise robust security measures. This is of particular importance where a threat actor's unauthorised access and infiltration and exfiltration could leave data subjects at serious risk, which continues to be a central driver for ICO enforcement action more generally. It's also a reminder of situations that the proposed new UK Cybersecurity and Resilience Bill may try to address. Here, advanced falls outside the scope of the current NIS regulations, but could fall under the scope of the new bill outlined in the King's Speech, which will expand the NIS remit to more digital services providers, particularly those within critical infrastructure supply chains. Also, while controllers may take comfort that the ISO is focused on the processor here, it does still underline the importance of undertaking adequate due diligence on suppliers to make sure that they have processes in place to be compliant with all of the requirements of the legislation. So moving on to the next slide, this actually leads us on to a recent German local court decision which focuses on just that point. What was interesting in this judgment was a finding that in circumstances where a processor had failed to delete data at the end of a services contract, which was in violation of the DPA that the parties had in place, which we would usually expect to be purely considered a processor breach, the court found it crucial that the controller hadn't actually ever audited its processor and actually found the controller liable. This is interesting because while we're all aware of the audit requirement under Article 28, which requires processors to allow audits by controllers so that controllers can monitor processors' compliance with GDPR requirements, this is commercially often diluted, such as by including various caveats like restricting the frequency of permitted audits, requiring processor consent before an audit can be undertaken, audits only being available if there's been a known breach of obligations, and in some cases with large corporate processors, the customer is simply given a right to terminate should it not be satisfied with the audit documentation offered by the processor itself in lieu of a specific right to audit. So it'll be interesting to see if this German case is followed by other EU courts or indeed in the UK and the potential knock-on effects on processor contracts, particularly those large corporate processors offering services on a one-to-many basis, which commercially and operationally may struggle to provide such direct customer oversight as this German case suggests is necessary. So moving on to the next slide, I think Martin's going to now do a quick update on cyber.
Thanks, Rachel. Yes, so I'm just going to pick up on a couple of cyber points, some developments in terms of new laws that are imminent or coming down the track. So we just move on to the next slide. So the first one of this is just around NIS 2. So this is, you'll be familiar with NIS 1, the original EU directive, which was implemented a number of years ago, which sets out EU-wide rules around cybersecurity for essential operational national infrastructure and in relation to some digital services as well. And this applies in the UK post-Brexit. But the European Commission a number of years ago published a new directive to enhance the NIS regime. Now, the deadline for compliance with that was 17th of October this year. As a directive, it needs to be implemented in each member state. But many states have not yet published their implementing legislation yet. So we're still waiting to see exactly how a number of member states will do this. But I want to put it on the radar for two reasons. One, if you are a multinational and you have subsidiaries in the UK, in the EU, then you may find that some of those subsidiaries are now caught by the new rules. So as an example of some of the new sectors that are covered, food production, food distribution is covered, there are also enhancements around some of the IT service providers that are covered, and some other areas as well. There are exemptions for small organisations, and there is a sort of tiered approach as to how organisations are expected to comply with their obligations. But it is just worth thinking, as if you have subsidiaries outside the UK, checking to make sure whether any of those are caught by the new rules, and you've got appropriate procedures in place to comply with that, including comply with the new instant reporting obligations. The other reason I wanted to mention this is, as Rachel has just said, in the King's Speech, there was a Cybersecurity and Resilience Bill, and this is essentially the UK counterpart to NIS 2 in terms of updating the UK's cyber resilience framework. Now, we don't have much detail on this at the moment beyond a government press release, which says that it will cover expand the scope to cover more digital services and supply chains, but we also expect it to cover some new sectors. We also know that there'll be stronger powers for regulators as well, and new reporting obligations, including a requirement to notify where you have received a ransom demand. So we don't yet have much detail on this. That will be coming. We expect the bill to be published in the course of 2025. But I think in terms of what's happening in the EU around NIS2, it gives a good indication as to where I think the law will go and some of the stuff that we will see coming in the UK. So just want to have on your radar, but do expect the cyber resilience obligations to be expanded into new sectors, and also to pick up things that, as Rachel mentioned, around IT service providers as well. More of those will come within the scope of the framework. Rachel, back to you, I think, for talking about cookies and DSARs.
Yes, so just a quick overview of some action that's been happening on cookies. So next slide, please. So in October 22, the ICO opened a regulatory investigation into Skybit off the back of a report commissioned by a gambling pressure group. And in the course of carrying out its investigation, the ICO identified that over a period of a few months, web users visiting the Skybit website had third-party ad tracking cookies placed on their devices prior to having any opportunity to give or withhold consent for processing of their personal data. So users were provided with a cookie banner on arrival to the Skybit website. However, before the cookie banner had loaded or the user had had any chance to indicate their preferences via the banner, around 40 individual cookies which gathered personal data relating to the users had already been placed on the user's device. So it's not surprising that in issuing the reprimand, the ICO found that Skybit had breached Articles 51A, 61A and 7 because it didn't have a legal basis to collect personal data prior to individuals interacting with the cookie banner, and therefore the consent it did purport to collect was not valid. So more widely, this action links to the ICO's actions last year to write to 100 of the most visited websites in the UK about their compliant cookie banners. While there's been a varied reception to that, the majority written to have made changes to their practices based on the ICO's letters, for example, around them making their banners more compliant. But one other point just to flag is what's also interesting is that linking to our last update where we spoke about consent or pay, what we have seen in practice is actually that a number of websites in practice are now moving to consent or pay. And while the ICO's press release could be read as implicitly endorsing that approach, as it claims the letter writing campaign has been effective, we're still awaiting the ICO's final guidance on consent or pay and the circumstances in which they consider it to be lawful. So we do expect that guidance to address some of the points raised in this Skybit case, such as requiring operators to carefully assess on a case-by-case basis the balance of power and whether consent is fairly and freely given. So moving on to some learnings that we've had from DSARs. So there's been a couple of interesting cases in the UK and the EU, which we'll just quickly touch on. So firstly, in the UK, while we've known for a while that data subjects should be told about the specific identities of the recipients of their information, rather than simply categories of recipients where it's possible to do so, a case from earlier this year in the English courts added some conditions around when that is not suitable, which offers some interesting insight into the interplay between those Article 15 rights of access and the protection of third parties exemption in the Data Protection Act 2018. So in this case, a requester had asked for information on recipients of telephone call recordings between the requester and the director of a defendant company after it became clear that the recordings had been shared with a number of employees, but also family and friends of the director and the wider business community. So while the court decided notwithstanding that earlier case law and that providing the detail of recipients can be interpreted to also mean individual employees, which was an interesting point. Controllers do need to also think about balancing that with the protection of the rights of the recipients. And the facts here lended themselves to support non-disclosure on the basis that the requester's behaviour was found to be seriously persistent and menacing, as he threatened violence to compel the defendant's compliance with his demands for access to information. Therefore, in this case, the refusal to disclose the identities of the recipients was reasonable and not a breach of Article 15 because of the risks of intimidation that some third parties could suffer should their identities as recipients of information be disclosed. That case also clarified what we should think about when deciding who is actually a relevant controller in the context of a request. The requester there had made Article 15 requests of a company director and of the company itself. But in its judgment, the court reminded us that while sometimes directors can be acting in their personal capacity, they will usually be acting as an extension of the controller, except where it's clear that they are acting in a purely domestic manner, which is unlikely to be the case when dealing with company affairs. This point was also followed by another recent English case where requests were made to charity as well as individual trustees. Again, the court there acknowledged that while there can be circumstances in which a trustee or consultant would not be acting for the charity and would themselves be a data controller, it's not because a legal person must act through a natural person that it's correct to reach the conclusion that that natural person, i.e. an individual trustee, would then be a controller in their own right. On the EU side, the first case to touch on is from 2024. It's a Dutch court decision in relation to X, and a request made to X by a data subject who wanted to understand why their account had been restricted. In responding to that request, X pointed to its website privacy notice to explain how it processes personal data. But the court in Amsterdam here found that in order to fully discharge the obligations around providing the supplemental information controllers must provide the data subjects, the privacy notice in question didn't meet those requirements of being concise, transparent, intelligible, etc., because it wasn't framed in a way that was sufficiently concrete or definitive, as it used too many mays, coulds, and possiblies. This meant that the privacy notice pointed to didn't actually answer the question around how the specific requester's account was restricted. So this is just a useful reminder to ensure that we don't focus too much simply on providing copies of information in respect of DSARs, and we do also pay sufficient attention to the supplementary information we're also required to provide to make sure that in respect of the individual data subject who has made the request, the privacy notice that we point to is actually relevant, and if not, it's either updated before the response goes out or the response letter provides that additional information on how you process personal data if it's not found in the privacy notice. The next learning is from a preliminary ruling from the CJEU after a reference from a Croatian court in relation to a group of data subjects' requests for various information from a bank relating to loans and account statements. And considering the duties of the bank, one of the questions the court looked at was whether Article 15 should be interpreted as requiring that controllers provide data subjects with full copies of documents containing their data, or if copies of just the personal data would suffice. The court's outcome was that yes, data subjects should be provided with full copies of information which contains their personal data if that full document is required in order to ensure the data subject has sufficient and necessary information to ensure the completeness and accuracy of their information, which they can only do in practice with that additional context, as opposed to if only simply provided with extracts. And the last learning comes again from the CJEU in relation to a request made in Austria to a credit rating agency. The requester was seeking information about how the agency had used an automated credit assessment process to come to the decision that the requester had insufficient creditworthiness. In summary, the court said that in practice, giving individuals meaningful information about the logic involved in any ADM, which is the requirement of information to be provided under Article 15, should be considered in the context of allowing individuals to then have enough information to be able to exercise their rights under Articles 21 and 22 in respect of ADM, such as the right to be able to object. So what this requires in practice is then making technical information made intelligible and comprehensible to data subjects, which might require additional explanations from the controller to enable a data subject to understand the causal link between ADM technology and the resulting decision. However, interestingly, the court stopped short of requiring controllers provide information which is overly technical, and the court here said that providing information on the underlying algorithms would be such information that wouldn't need to be provided. So here, in relation to ADM processing, meaningful information about the logic involved required in practice the controller to provide accessible information around the processes used to come to decisions, such as criteria and the reasons for the outcome of that decision, but it didn't need to be the full technical underlying algorithm information, which would likely be too complex for most data subjects to understand. And that's me on that.
Thanks, Rachel. So we've got a couple minutes left. The next slide there is just around some horizon scanning in terms of things that are on the are coming down the track. We won't talk through these just now, but you'll get the links in the slides when we send them out. I think we've got time probably for 2 questions just before we finish up. So Grant, can I take you back to the DSG case? And I suppose just some comments, thoughts around the practical impact on that on controllers. I appreciate we're some way off a definite decision, but if the Supreme Court ultimately was to uphold the upper tribunal's decision, just some thoughts around what impact that might have for controllers in terms of how they look at what they're doing with personal data.
I think the most obvious one is how you store it and how you divide it up into different areas. So actually, you've got vanilla data, vanilla data in different places. As a controller, yes, you can unlock it, but actually, if it's compartmentalized and actually the loss of that data would not constitute personal data in the hands of the third party, then that takes you into a different place in terms of reporting a data security breach, because the logic here is that isn't a data security breach. So I think if this is upheld all the way through, then I think there will be organizations will start looking at how they hold their data in different ways with different kind of segmentation internally. So that ultimately may make a difference to whether or not they have failed to discharge the security principle. The thing I would say, I mentioned Regulation 26 of the directive, and that actually also, that there is sorry, I said recital 26 of the directive. There is an equivalent recital actually in GDPR itself, which is also recital 26, confusingly, and it makes the same point. So that issue around identifiability in the hands of third parties, I think applies under GDPR. It's not just a 1998 decision. What comes out of that, what comes out finally, will have an impact, I think, in terms of how organizations look to hold their data.
And I guess just following on from that, in terms of sharing data for, say, AI training purposes, if actually the concept of personal data is much narrower, that is also something potentially relevant in terms of if you disclose something that has been in that format, is that no longer personal data, and therefore do you need to worry about, I guess, is the other thing that may
although I think this relates to data in the hands of third parties. So you would be having to, if you were disclosing it out, then you still have to pass the threshold for actually the initial processing before you disclose it. In a controlled disclosure environment, you still need to be able to show that there was a lawful condition for what you're doing to that point. But once the data's out, if it is vanilla data, then it's no longer personal data for those purposes.
Yeah.
I think that's been consistent with how a number of FOI cases have run in the past.
Yeah, thank you. Rachel, can I just take back to the advanced computing case? I suppose just to comment on that the case, I guess, will be welcomed by controllers in terms of that allocation of risk and the fact the ISO is now starting to look at processors. But I guess what you're saying is that while the ISO may look to take action against a processor where there's been a failing in terms of security, the German case you flagged makes clear it's not a free pass, I guess, in terms of your diligence, and you can't just take too much of a backseat in terms of the processors you use.
Yeah, absolutely. And there's, specific obligations within GDPR on controllers to make sure that they're using reliable suppliers as well. So we shouldn't forget about that. And I think that's also consistent with other decisions from the ICO in the past, and not particularly as recent as this German case around controllers making sure that they also use processors that do have appropriate technical and organizational measures in place. So yeah, it's definitely not a free pass. I think it's definitely useful to show that processors can be targeted, and it's useful for processors to be aware of that and give comfort overall to data subjects. But it definitely doesn't change the landscape too much.
I think there's an underlying tension between this idea that almost as you go down the supply chain, that the controller is the one with all the bargaining position. Ultimately, when you're dealing with behemoths, in terms of tech companies, you can get the rights or you can get an element of the rights that are required by GDPR, but then exercising them is a completely different kettle of fish. And a lot of controllers do not have the technical expertise or capability to be able to actually meaningfully do those audits. And, I think that's where the German case is really interesting, because, the reality is that actually going to audit a Google or a AWS or something like that is tremendously tricky for large organizations, never mind small ones.
Yeah. And all that remains for me to say is see you in May for the next update. Thank you very much.
Cheers.
Okay, bye.